Next week, we're going to look at market abuse, and we looked at the civil liability regimes for investors to protect themselves directly against the misstatements made by companies last week. They are private law enforcements, and we did discuss that private law enforcements, the civil liability regimes, allowed investors to ask for compensation for their economic losses, but we know for misconduct on capital markets, there may be harms beyond economic losses, and in many other cases, the harms to some investors are not direct, and then there may be economic losses which can't be clearly calculated, or there may be economic causes, but as a matter of law, we can't find a clear causation, or we could say that misconduct is not a cause in law for the economic losses. But for all these issues, private enforcement cannot solve them. We need the public power to step in. So that's why we have the legal framework or legal regime of market abuse. That's why it is called market abuse. So the abusive activities have an impact on the market as a whole. So it's the public power's responsibility to look after the market as a whole. Of course, for any individual investor, here it's not individual is not opposed to institutions, any particular investor. So their risks actually are also the risks they are actually also reduced. Okay, so we're going to look at the public enforcements against, but not only misstatements by companies, but also by any potential market players who will plan to or who have the incentives to abuse the market as a whole. So we're going to look at market abuse, and you may find that in some literature that academics maybe say insider dealing and market abuse, in which context the definition of market abuse seems narrower, which excludes insider dealing. Some academics may use insider dealing and market manipulation. So not very clear in the academic context, but as a matter of law in the UK, so we use market abuse as the high-level term, the umbrella term, which includes insider dealing and market abuse. Market manipulation. Right. So insider dealing and market manipulation, their legal structures are different. So we will leave market manipulation to next week. But when it comes to what we say the commercial nature of all insider trees, when we look at them, they are pretty much just the same. Very straightforward for us to understand when it comes to the business, transaction structures or the commercial nature of all insider trees. But next week, when we look at manipulation, you will find, it's hard to give a one-size-fits-all definition in law, and this is because there are so many different transaction structures. They have something in common, but they may be organized very differently. And when we talk about market abuse, it's manipulation which involves a lot, along with the development in technology like algorithms and so on, various insider dealing. Its commercial nature or the transaction structure is pretty much just the same as like 30 years ago. We're going to look at the essential elements in insider dealing. So here is like one of the differences. We will talk about the differences between the two briefly next week as well. So just what you need to take out for now is just market manipulation itself is an umbrella term which includes many different transaction structures. But insider dealing is pretty much just straightforward, and different trees are actually the same. Okay. Here we go. What we're going to do today, we're going to start to look at insider dealing briefly. You're going to talk about your understanding about insider dealing, we briefly look at some elements, or just roughly, because when we look at their definitions in law, we will discuss in more detail. So we look at what insider dealing is based on the general understanding. We are going to look at the borrowing theories, telling us why insider dealing should be prohibited by law, and then we move on to the still borrowing legal rules. We are going to look at, I put them, let's change the structure a little bit. As you can see that I've divided the criminal offence and the regulatory offence into two different parts, but we are going to look at them together. We will focus primarily on the criminal offence, then we integrate the definitions of different elements, what they mean, and when there are differences, significant differences between the regulatory offence and the criminal offence, I'm going to highlight them, and we also think about how they affect the implementation of the two different offences, instead of we looking at the two offences separately, because it's not that meaningful to repeat some of the identical elements or definitions again. And of course, while talking about the legal rules, we're going to bring in cases, and hopefully you will find the cases exciting. Okay, that's it. And so let's start from a general understanding of insider dealing. Can I ask someone, in your own words, just briefly explain to us what insider dealing is? Anyone want to try? Insider dealing. I guess you heard about the term before. Okay, Luis.
So suppose the way I think about insider dealing is it's when someone makes trades on the stock market to make a profit, but they only do so because of information that they have by virtue of their position that they wouldn't otherwise have. So, for example, if you're the director in the company, you know what decisions you're going to make for your company before anyone else can know them, and so you're able to trade on them and make a profit. And if you weren't a director and you didn't know what decisions you were going to make, you wouldn't have traded and you wouldn't have made that profit.
That's brilliant. And before we get into the details, any other opinions about insider dealing?
To make it like insider dealing or insider trading, there would need to be like a precise piece of information, so knowledge of like something specific that was going to happen. It couldn't just be like we will exceed revenue this year by, because it could, that kind of information could be any number. It doesn't need to be significant. And then also there would need to be a clear pattern of buying and selling, I believe. Like if you say Lewis is director of Lewis Incorporated and he goes on the market and buys, I don't know, 100 million shares because he knows there's good news coming up, that's all well and good. You may have bought at a good time, but if he doesn't then sell and take a profit, he's not trading.
We're going to look at the definition of dealing, but pretty much the definition is not limited to what we usually understand trading. Go on, please.
So it's not limited to that?
It's not. It's not limited to the exact trading of the securities or the commence of the trading or the completion of the trading. It's have a relatively broader definition. We're going to look in law. It's not just what we usually understand in a commercial context. We're going to look at it later. But thank you, Luis and Elliot. I think you've touched on several essential elements. Let me just recall Luis' answer. Yes. So there must be a piece of inside information, and that creates the information advantages. Luis' side. This is the motivation for the person to trade, and this actually Luis has touched on the causation. We're going to look at that's a very significant issue. We're going to look at through a case at the very end, and then Elliot also touched on conduct, the act, the act is, we call insider dealing, so it's dealing, but let's leave it to look at the specific definitions in law. So we probably could, in our own words, not very precise, but briefly, insider dealing means someone has acquired, which could be considered as inside information. So while he's in possession of the inside information, he treated the relevant securities to make a profit or to avoid a loss anyway. And then several elements we need to interpret. First of all, what I think both of you actually overlooked is the definition of the insider, because you made an example of director or hi, good morning. So insider is not limited to a director or someone which is equivalent. It has a much broader definition. We will look shortly. So the first element, insider. There should be a person, right? That the person is an insider. And the second is inside information. You both mentioned, which means inside information is very important. Later when we look at, there is a very broad definition of the insiders. Literally anybody may be considered as may have the potential to become an insider in that case. Then what information is inside information becomes essential. Because if everyone may have the potential to become an insider, it depends what kinds of information this person has relied on while trading. Then dealing we will look at later. And then when it comes to acquisition, if we look at the examples given by Louise and Elliot, we can see there are two acts. The first is the acquisition of the inside information, right? So the person is in possession of the inside information. Or this can be regarded as a status. And the second is the trading. So two acts. And there should be a causation between the two, which means the causation between the possession of the information and the trading, which means the trading should be caused by the possession of the information. Just as Louis said, if the director does not have the information advantage, he will not go to the market and trade. Or in both criminal law and regulation, you will find this causation is presumed. And this is known as presumption of use. Because we are not going to ask the regulator or as when they act as the prosecutor as well to prove that this person relied on the information to treat. We presume it, unless the insiders, the person who was accused, could have reasonable grounds to rebut. So we're going to touch on this. So there are four elements, and you will not find a very clear definition or interpretation of the causation, because no matter in the definition in criminal law or in regulation, because it is presumed. And then when you look at the definitions or some interpretations, you will find they explain who may become insiders, what insider information is, then what dealing means. Then there is an implied element, which is the causation I'm going to look at. So are we all clear about the general picture or any questions so far? Okay, that's brilliant. And then we have a quick look at insiders, and then perhaps we don't need to look at in detail when it comes to the criminal law. Then Louise and Elliot made examples of like a director. So of course, a director or a senior manager, every day they have access to the inside information of their companies, and we may also extend the scope of insiders to other employees. Even ordinary employees may have opportunities to access if they are the secretaries, even cleaners, when they are tidying the print rooms, and anyway. And so they are working in the company. And there are also people who are working with the company. They are not part of the company, but they can't access inside information through their employment, through their work. Any examples? Okay, Alex.
Any advisors, so consultants, lawyers?
Brilliant. Lawyers, auditors, consultants, and Ruben?
Yeah, I was going to chuck in like investment bankers, underwriters, like sponsors in IPOs or M&A deals.
Brilliant. And also regulators, staff members in regulators. Okay, yeah, that's brilliant. Or they're like in the councils and so on. And so let's assume that if the law just defines insiders as those people, is it adequate to cover all the possible insider trees? Ruben, how do you think?
Well, that's why they have the secondary insiders class, right?
Brilliant. So, what is secondary insiders?
I mean, I can't say much more than what's on the slides, but essentially anyone who is told inside information by a primary insider is a secondary insider.
Fantastic. So, if I look at the scope of secondary insiders, so secondary insiders, they particularly mean someone who may be defined as the recipient, and they who does not fall into the scope, the scope of primary insiders, those people we just described, who does not fall into that scope, but who may become the recipient, and the source is someone falling in the scope of primary insiders. So, because those, we know that directors or employees, they have a frequent access to inside information, or if they do not treat themselves, if they tell someone the inside information, they instructed that person to treat, they may easily circumvent the law. So that's why we need to bring in the concept of secondary insiders to ensure that the scope is wide enough to cover all kinds of inside trees. And that's why if there is like a tipping process which allows someone else who does not have direct access to inside information to treat, but based on the inside information, then the law should also penalize this kind of like illegitimate activities as well. So literally we can see that because we bring in the concept of secondary insiders who are TPs, and then anybody may have the potential to become insiders. So when we look at the legal definition of insiders, it is not the definition of an actual insider, it's a definition of a potential insider. So an actual insider, it depends on this particular case, but in terms of a potential insider, everyone among us may become may have the potential to become an insider. Is this clear? So that's why we would say inside information is really important. The definition of inside information is really important. And okay, so then when it comes to inside information, first of all, how do you understand inside information? What does inside information mean? Any idea? Is insight
public material, non-public information?
Not public information. It is not available to the public. Okay, and Luis, anything else?
No, that's exactly what I was going to say.
Okay, so what? Thank you, Dom and Luis. That's absolutely correct. And a piece of inside information is something which is not available to the public. And by saying that, you emphasize the confidentiality of the information, but this is only one of the defining features of inside information in law. We know when we talk about inside information, when we focus on inside, then we tend to think, oh, if something stays, the information stays private, then that is inside information. But let me give you an example. Let's say, Apple has just got a new technology. I don't know what the technology is. Was related to smartphone. Has just been successful. The technology has been successful. So we know, but the technology has not yet disclosed to the public, and this is inside information. Yeah. Okay, brilliant. Let's say yesterday, Apple's employees, staff, had a party to celebrate the new year, not disclosed to us. Is this inside information?
depends what happens at the party, I guess.
Yeah, probably I need to give a bit more details. It's just let's say, just a general Christmas party. And then,
by definition, it would be.
by definition,
It would, because it's not publicly available. I would say it is.
it's still public. Sorry, it's still inside information because.
By definition, I would say so.
Because anything is not made public is inside information. Is this the definition you sharing? Yeah. So the focus is the confidentiality. Okay, sorry. Elliot and Louis, what do you think?
I was just going to say it doesn't seem like it's materially important.
Yeah.
And it's reasonable to assume that it's a publicly available piece of information because it's told to spouses. I mean, it's a plan, right? Off-work plan, Christmas party. I mean, it's probably like.
You guys are so smart. You go into the details of the party. Let's say the party is not relevant to work. It's just.
Yeah.
Okay, so Victor and sorry, please. I think got so many answers here. Let's go one by one. So, Elliot, Louis, Victor, right, and then Cameron, and Ben. Yeah. So sorry, guys. Are you happy with the order? Okay, one by one. Elliot, please continue.
Okay. Yeah. Well, like it's not work commitment, and it's reasonable for it. The arrangement to be shared or open to other people even, so we don't know any information, but it's probably not insider.
I mean, do you think it's necessary for Apple to disclose? We just had a party yesterday for fun. We went to the pub after work. Okay, I think this is clear. So they went to the pub after work yesterday.
No. It's not reasonable.
You touched on a material. Let's keep it here. Then Louis, how about you will?
Yeah, I suppose because if you're justifying insider dealing, what really matters is the fact that the information would affect the stock price. So, saying, oh yeah, we went to the pub yesterday after work. Like almost every company goes to the pub after work most days. So it wouldn't actually affect the stock price unless, like Ruben said, something terrible happened when they burned down the pub. But yeah, unless it would affect the stock price, then there's not really any reason to prohibit people sharing it. Or if you would trade on it, it wouldn't matter.
Yeah, let's do not try to imagine too much. Let's say nothing is related to work was talked about during the in the pub. Victor, how do you think?
I was just touching upon the same topic basically. So the information, if it was to be disclosed, should have a significant, on the price. The price would be.
So it does not matter if the information, or let's say physically defined information, is something that trivial about the stock price, about the performance, about the company's status, then we don't care. The market does not care whether it will be disclosed or not. Only those types of information which we consider are significant will have a significant effect on price. Then we consider they are materials, which is equivalent to the materiality given by Elliot and Cameron.
Everything I was thinking has been said.
Brilliant. And Ben?
Yeah, that's just the same. It won't affect the price of investing, so there's no real relevance to the information for it to be disclosed either.
That's brilliant. Thank you very much, guys. So here I just want to say that we may consider confidentiality first when we look at inside information. But it's also important that we also need to consider whether the information is material for what. This is another issue. We could see that material for the market to make investment decisions, or there may be a significant effect on price. So we also consider the materiality. So two defining features, confidentiality, this is more straightforward for us to understand than of materiality. So two different defining features when it comes to inside information. So the second example, going to the pub, that's if something is trivial, then that's not inside information in law as to insider dealing. But what kinds of criteria will apply or standards will apply to assess the materiality of the information. Later, when we look at the definition of inside information, one of the elements is likely having a significant effect on price. This means we use the price sensitivity standard. We look at whether the information will have or likely will have a significant effect on the price. In academic discussions, we will also, but also later we'll look at the must-see that case. In judicial practice, there seems to be a different one, which means whether just any reasonable investor may take into consideration while making investment decisions. And there are just the debates at these two standards just the same, because we could say that any reasonable investor, then they will only consider, this is in the context of capital markets. So we assume that the reasonable investor, what this person cares about is just price, profit, and just price. So they will only look at any reasonable investor. They will only look at information that will have a significant effect on price. So these two standards should be the same. Or on the other hand, we could see that any reasonable investor will take into consideration this piece of information, which means, if we assume that there are many reasonable investors in the market, then reasonable investor will take into consideration the information, then of course the information will affect market price. So following these arguments, the two standards are just the same. Okay, Luis?
I was just thinking, because it's a reasonable investor standard, I'm only thinking this because I was thinking about negligence and something else. So, because it's not what an ordinary investor would do. It's not. It doesn't matter what factually, if you could survey every investor in the capital markets thing, it doesn't matter what they would do. It's saying what would a reasonable investor do, because that's different from saying what every other investor would do. So you already have to have a standard of what an investor would do, and what standard would that be other than would the information have a significant impact on the market price. So again, I would argue they're essentially the same standard, because you have to pick some standard for the reasonable investor standard.
Okay, so brilliant. Here I just want to introduce the two different standards. Let's have a look at whether there are some differences or they are actually identical. I think I've got the argument. Let's have a look at later at one of the cases, which is messy, and we'll try to understand. It's just the upper tribunal. They've got different reasonings in different cases. We look at them together, and later, after looking at the case, we're going to discuss. You can share your ideas whether you think they are actually identical. They should be identical, or whether they are just identical, or you think there should be. Or we may interpret the two standards in different ways, and they may suggest there are, of course, overlaps. They overlap significantly, but whether there may be some slight differences. Okay, so let's look at this easy. But here I just want to bring in that it's not that easy to define inside information, and especially the materiality. So when we define materiality, or whether our information is material, or some discussions by academics as well as in judicial practice. Okay, so here's some theories. Why do we prohibit insider dealing? Let's just only briefly touch on the alternative justification, which has been abandoned by at least in Europe, but it is still going on in the US. So here, the focal point of the relationship-based justification is that only when a duty arises in a legal relationship will someone be accused of insider dealing. So if someone does not have a duty, this duty actually is based on private law. Okay, but if there isn't, and the person does not have any duty, and we're going to look at what the duties are, then this person will not be considered having committed insider dealing, and that was the traditional position in the UK law as well many years ago. It's not the modern way to consider the rationales for prohibiting insider dealing. Okay, so I think the most apparent duty is the fiduciary duty of directors. What is the limit of fiduciary duty? If we only consider insider dealing in the context of fiduciary duty, what happens then? Fiduciary duty is limited to like certain people, right? Directors and then just senior managers, even ordinary employees, they do not owe a fiduciary duty to the company, or let's consider those not corporate insiders, but another temporary insiders like agents. It's hard to say they do have a fiduciary duty. This just depends. And then it means that if someone does not have a fiduciary duty, then someone will never commit insider dealing in law. That's a problem. Then that's why we also need to consider another types of duties in law. So that's why we got the duty to the source of information, which comes from the duty of loyalty and confidentiality. You may understand this better. So if there's a clear legal relationship between the tipper and the TP, then clearly, you can't disclose the information to someone else, and you can't treat on this information, because if you have committed to keep it confidential, then you have a duty coming from this legal relationship. This is the duty-based or relationship-based approach. What about, let me make an example just I'm a director of the company, and I do know something every day. I know something new about my company. But I just casual talk to like Ruben, Louise, everyone here. We're just the casual talk between friends. I tell you something about what's happening, what's going on, or I tell my family members what's going on every day, without a explicit commitment. Without asking you to make an explicit commitment to keep them confidential. And in the casual talk, it's hard to establish a relationship in law. Well, regardless of my problem, so my misconduct, just considering you guys, then you guys you're going to treat the securities, the stocks of my company. Do you breach any duties? How do you think? Okay, Louise?
It'd be really hard to argue that you did, because you can imagine the example given in the reading is, a waitress overhears directors talking about the plan that they're going to do for their company. It's that waitress has no connection to the company whatsoever. So it'd be really, and as well, it'd be hard to say that she has a relationship to the directors as well, because as far as, like, for example, even if you were to go into something like negligence, it'd be hard to say if she bought their shares and it made their share prices go up. It's hard to say that she's harmed them. I think it would be hard to establish a one-on-one relationship.
Exactly. In the example, that example is very good. So in that example, it's hard to say that the data has any relationship in law, right? There are contacts for no relationship in law with the weakest clients of the customers, who are actually insiders, and we mean the primary insiders. But here, this was ever the problem in U.S. law, but they actually just extended the duty. So that's why they've got the misappropriation theory. So in addition to fiduciary duty, which is a very clear explicit duty to the source of information, these two duties may be extended to a potential TP, but there is a prerequisite to establish the duty, which is this person, the TP, clearly knows that the TP clearly knows that the tipper has breached his or her duty while disseminating the information. So it's about the mental element of the TP. So they have effectively extended the fiduciary duty or the duty to the source of information to the potential TP, even if there is no any clear legal relation between the tipper and the TP. So it's an extended duty. So an extension of either the fiduciary duty or the duty to the source of information. Ruben?
I got slightly confused in the reading of this. Is this an objective or subjective standard, this mental element?
Let me try. The mental element of the TP, what do you mean by subjective or objective?
Well,
a reasonable person should know.
Yeah, or is it like the specific person? Do you need to prove? Does the regulator need to prove that the specific person was aware that the information was insider, or do they just need to prove that any reasonable person in their situation would have known or would have been would have worked out that it was inside information?
For sure, in criminal law, this definitely subjective but it applies to the particular case, whether the person, we know in criminal law there is a higher standard of proof, and the prosecutor needs to prove that this person in this particular case knew this was inside information from the insider source. This is pretty much the same in the US law and the UK. Then when it comes to regulation, because in the UK no mental element is actually required in the majority of the situations, it becomes that's not an essential issue whether the person should have known or not. And I'm not really that sure, to be honest, about the position of SEC in the US about they adopt a negligence standard or not. And based on the readings, I tried to recall the readings regarding the US, the SEC's position in particular. I think they also, it's quite, I think they're on the same page. They don't really need mental elements. But sometimes you will find that because from regulators' perspective, if they do have evidence showing in your position you should have known, they will use that. It does not mean that that's a necessary element in regulation. So if no mental element is needed, then the regulator does not really need to prove, that person should have known. Is this clear? But when it comes to criminal law, then it's a different issue, and it's not. Any reasonable person should have known. It's not in that case. I believe that is subjective. Okay, is this clear? As a matter of legal practice, I just want to let you know, you will find that there are only a very small number of criminal law cases regarding insider dealing, because I think different reasons, but one of the main reasons is just the highest standards of proof as to mens rea, and we later will touch on that, especially in the context of the UK law. We won't find a lot of cases in criminal law, but we do find quite a few in regulation, just because the proof of this burden of proof is pretty much reduced, not only as to the mental element, but also later we'll talk about reduction of use. Okay. Right, so let's see as approach based on duty. It's a little bit, do you think it's appropriate to keep, well, of course we have abandoned the duty-based approach, but the US still its own. How do you think about this approach? Any problem or any merits? Ruben, would you like to try?
Well, I think for me anyway, if I think of insider dealing, I think about it wrong on the market rather than wrong on the company. Because if you buy shares in a company with inside information, you inflate the price, it's good for the company. If you sell shares in the company, you deflate the price, it's bad for the company. But that's not got very much to do with the inside information, it's just buying shares is good for share price, selling shares is bad. Whereas in the market, affecting how the market actually reflects the material facts of the company, that feels like a much clearer relationship. Either buying or selling both harm the market, both harm investors who are not privy to the inside information.
Fantastic, brilliant. So it's actually the discrepancy between this doctrinal position, the traditional doctrinal position, and the modernized understanding of the function of market abuse regulation, and including criminal law. So market abuse, the legal framework of market abuse is to protect the market as a whole, is to maintain market order and integrity. But if I look at the duties, these duties, they are based on, as we just discussed, private law. So you can't really, if you just confine the scope of insider dealing to private law duties, then in terms of its function, the function which is to protect the market as a whole, it's inadequate. I'm not making any sense here. So it's a discrepancy between the traditional understanding or the doctrinal foundation and what we usually understand the function of market abuse regulation. Okay. Any questions?
Just one more thing on it. It feels odd for a public regulator to rely on private law duties. Like you'd expect if there's private law duties involved, you'd have the company go after the inside trader directly because the company is the only thing that's been wrong. Whereas in a regulator, it's about public law, it's about protecting the public.
Fantastic. Very, very good. It's a very good point that public regulators shall rely on their own responsibilities arising from a public law with a public law foundation, not private law foundation. And also another problem is that for insider dealing, for example, and market manipulation, well, individual investors, they do not have any, they can't sue the parties themselves. They can't rely on the private law. There isn't any private law provision, but they can't rely on the provisions in relation to insider dealing. So the provisions, the law itself is actually in the domain of public law or no matter criminal law or regulation, but the foundation is private law, so there is the discrepancy between the two. Okay, really. So here we go. So that's what this is not a problem here in Europe, because we base the prohibition of insider dealing on just on the function of market abuse or the purposes of market abuse regulation. We consider the market as a whole, market order, market integrity, the confidence of all investors as a whole, not any individual investor. This actually has something to do with what we talked about last week, efficiency of the market hypothesis. If we assume that it's hard to achieve the strongest form, then if we only stay as a semi-strong form of an efficient market, what happens? People can't make a profit by relying on publicly available information, but they can make a profit. If they have inside information, then they can make a profit. And then in this case, then we know that a small number of investors on the market, they have information advantages, others don't. And as if we are uninformed investors, we may wonder, is that guy, my counterparty, an insider with inside information? So it's not fair. We are not on the same page. And that person has inside information, can always make a profit, but we don't have the same opportunities as those guys to trade on the same side of information. It's not unfair. It's all about how investors, uninformed investors perceive the fairness when they trade in the market, and whether this fairness is maintained by the market as well as market regulators. So if you think, well, there are always insiders, and you may actually at a disadvantage the situation while trading, some investors may just withhold their money instead of investing. And what will happen if some investors, because they do not trust the functioning of the market and the regulators of the market, what will they? If they withhold the money, what will happen then? It will not just harm those investors, it will harm Also, yeah.
It will harm the company seeking equity finance, and then that has a overall reduces willingness of entrepreneurs to create businesses, and then harms the overall economy.
Fantastic, very good. It will also harm companies because they will suffer an increase in cost of capital because there are fewer financial resources, and it makes it more difficult for companies to raise equity capital at least. Okay, so this is about a market-based justification, and because we just completely forget any duty, so it's not necessary to find a duty in private law, and that's why if you look at, we will also look at Einhorn, that case, that is that case by the FSA. But if we got a piece of reading which is written by American scholars. They actually focused on there wasn't a duty, but this person was still considered having committed insider dealing. Their focus is duty, or regardless of any duty, we would say that it's one at least in regulation. If someone is in possession of information, this person has treated the relevant securities pretty much, and this is insider dealing in the context of regulation, and that person will then be penalized by the regulator. This is to just to deter market players from committing insider dealing. It's very straightforward in regulation, but then when it comes to Einhorn, that case, our focus is not whether there should be a duty, but I think that case is also interesting and important for us to understand what what inside information is. We're going to look at it later. Okay, so are we all clear? Any questions so far? Questions? Okay, brilliant. We'll leave this case after looking at the definitions in law. Here, briefly, they are old-fashioned discussions. So I can assure you for sure, there is no consensus among regulators, among academics, that insider dealing must be prohibited for the purpose of protecting the market as a whole. Despite that, if you look at 4 or 5 decades ago, there were some debates going on, some economists and as well as lawyers trying to argue there were economic benefits, and because of the economic benefits, then insider dealing should not be forbidden. This is one of the arguments. Another one was you can't really find a traditional victim of insider dealing. Let's have a quick look. I'm going to explain their arguments, and I hope that you just please share your rebuttals. So let's take it for granted that take the consensus for granted that insider dealing must be prohibited. So first is that here are economic benefits. The first economic benefit is that it may improve information efficiency, because when the information stays private, it is not factored into the share price yet. The market has not reacted yet, and the market does not know. Some insiders know, so they treat, and they place their orders at different prices, usually higher than the current market price. They will move the market price closer to what it should have been, if assuming that information would be made public later. So through insider trees, several insider trees, and the price will be moved. Let's say we have assumed that information is positive. Let's assume that it's positive. Okay, so it will drive up the price a little bit closer to the most accurate level. How do you think about this? Are you convinced? Victor, how do you think?
I mean, because it's still just available to a certain part of people, so they basically make it a huge positive to have the information. So still the public loses out on these possible gains of the increasing prices. If you understand what I mean.
Yes. So what we mean is that actually there are only a small number of insiders,
Yeah.
and they they may move the price a little bit, but perhaps they won't achieve the efficiency as expected. Instead of allowing insiders to trade, in fact, we should ask companies to disclose so that the market will fully react to the information, and then that will achieve the accurate level. Whereas just through some insider trades, we can't achieve the most accurate level. And I'm not quite sure. And is my understanding correct?
Yeah, exactly.
Okay, brilliant. Any other ideas about any rebuttals against this? Pretty much, yes, it's just uncertain. Perhaps the insider trees are very small, depending on the size, the volume, especially if the market capitalization of the company is very large. They may not effectively affect the share price, but we consider they still make a lot of profits in themselves. Okay, and sorry, Louise.
Would that also be assuming, I think that argument also assumes that the market would be able to tell when it's an insider who's buying or selling shares, which I think at the moment, if they're just selling it on publicly listed stock markets, it might be quite difficult to do.
Yeah, I think that's connected to Victor's opinion. So, unless the insider trees are significant, which attract the attention of the market, another investors, and even if they are informed, they may guess perhaps they trade based on insider. They know something we don't know, and then that's why they trade a lot. They trade a large volume of shares. And then this is of course assumption. But if let's say that director does not have a lot of money to purchase, then he or she can only purchase a very small number of shares, and it's of course harder for the market to tell whether that is based on inside information or not. Okay, brilliant. And another one is related to corporate governance, and insider dealing can incentivize entrepreneurs and directors and managers because they will work hard to improve performance, to make more profits, and in technology innovation as well, and they keep the information private, and then they treat, they make investment, and then they make profits. These are equivalent to using, we say, stock-based remuneration. There's an alternative way to incentivize managers, in particular, entrepreneurs as well. How do you think? Louise?
I think the problem is that it makes it very hard for companies to get a director that won't inside trade, so it becomes hard to regulate it, because even if, let's say the company created a contract with their director that, you won't inside trade, if there's no public regulator, again, it's very hard to tell when the director is trading. And so even if they do bring on another director who says, oh no, I won't inside trade, that director still has an incentive to do inside trading, because all the other directors are as well. And so it becomes sort of a race to the bottom of poor quality directors, or directors who won't inside trade.
That's fantastic. And I think a further argument is that, of course, there are several different factors a lot of factors which may affect the stock price, and not necessarily improvement in business performance, operation, or technology innovation. And they may actually speculate on stock price by taking actions which it does not have any commercial merits, but it will just increase stock price. Sorry, Ben, any?
Perhaps we say it doesn't necessarily incentivize them to work in a positive way. They might decide to tank the price of the company, because it's not always people don't only profit from stock prices going up. If they've gone in a short position on a stock, then they might, if they're trying to short it, or if they've got a put option, they'll benefit from the tanking. So a director might do a deal that they know is going to drop the price of the stock, and then carry out a short selling position and make profit that way. And then that brings in your agency costs, and I think it just all round makes it worse, because you can't control what your manager's going to do, no matter how tight your contract is. they're going to do it if they're going to do it. So regulating is the only way to try and reduce that.
Fantastic. That's very good, and that's very important. The only issue is that we haven't talked about short selling yet. So this argument assumed that the directors and managers they have a long position. The long position which means that they expect the price of the company share price to go up. So they would like to hold the shares and choose to the future, and then we'll sell the shares when the price goes up in the future. But a short position, which means we expect the company's shares prices to go down, and let's leave it to week 9. So there may be some strategies. If you have a short position, you can still make a profit. Let's leave it. And also, managers may work to perform poorly, and then they can't, even if they perform poorly, and with insider information legitimate, they can also sell their shares in advance to avoid losses. This does not make any sense. Okay, and then quickly go to the last question. Is it victimless? Who are the victims of insider dealing? If, for example, Louis, if I'm the insider, Louis trades with me, and he does not know. Anyway, just at this particular time, you still trade with, for example, Elliot, an informed investor. Louis, how do you think?
Well, I suppose they're still the victim. The victim's just the market, so it's every other person in the capital market. And so I think in the reading it has a good quote, which is that there's still a harm. It's just the harm is spread very thin across a lot of people.
Fantastic.
And as you said before, if it disincentivizes people investing and people lose confidence in the capital markets, then that would impact access to equity finance by companies, and that would impact the whole economy, and then that's an entire country that's been affected.
Fantastic. I think that the victimless this issue is related to the duty-based approach, which means they still really own whether there is a private law relationship to find out the victim, or if we abandon it, we look at market as a whole. It's not an issue at all. So the market is a victim. So I think the questions are clarified. And please, let's take a break. When we come back at 20 past 10, we're going to look at the law. Okay. Oh yes, this one. Thank you. Do you need a pen?
Or don't go.
Yes, you are. So, actually, no, I don't know the signature. What
What is that?
I think that's
That's a very good picture. Is it yours?
No, it's exactly.
Me and my father.
No pasa nada. No pasa nada.
It was so like I was it's so much more fun than
Right.
it's we went out. That's quite sad. That's one so quite sad. but I'm in the field of half 6. Yeah. I've got to do the classes as well, because I've got to do the class meeting at 4, and that's all till half 6, so I mean it's not really like a class. Well, I'm meeting with one of my group projects in between, so I'm going to go to the business school after this, and I've got like 2 hours to like study, I'm just going to do something, I don't know what yet, but... No. I don't like coffee. I think that's just why I've never...
Yeah. I used to hate it. No. It's pretty like it is. I was pretty wrong with that for me.
Like in the mornings and that's fine, but like combined. And we've got presentations like the tops and algorithm and all class. On Thursday. So I'll be here in the morning. And then I'm going to do it. Right, no, sorry, Thursday, not Wednesday, so I'm going to be here. I've sent that before it. And then we've got 2 hours slots to go to the presentation. So just story things. We have to present 2 research papers and explain the papers that we're so I get to anything in corporate finance that's like, that's even I've read every textbook with this. But it's like I don't want to be exposed to reviews and empirical studies that are original data. It's original one reading. It's got to be bang on 9 minutes, you can't go over 9 seconds. Yeah. So I'm going to hold right up with my Apple Watch on and I watch his time on. If the group wants to, I sit down and let it go and go over the time. Because I was like, sort of like, some stuff, oh, okay. And then on me goes the next one. What are the classes are you doing next week? What was that? I'm not allowed to take on. I didn't do the prerequisites. I mean, all it was says is what's in the book.
The thing is, it's just not like words or we were just talking about countries and how we accept people. It's like, do we accept people? It's not really sort of that's it. It's good way to yeah, so right, I think that's probably also. But
I don't know, it's fascinating.
it's really
Is it stitched?
yeah.
It's not nailed. That's some scissors and stitching. I didn't do it. I have to send it to stitch. Should it cost them to stitch it? I mean, if we're talking again, it's keeping costs as well, so stop stitching. I'm just disputing it.
Yes.
I don't think this is that is the answer.
It's actually so weird.
I just have a little meeting here.
And it's quite mild, like,
You just have a quizzing me on
it's
class.
just like, oh,
Well, to be honest, that's what my global my essay. And then, where are you going this time? And I was just like, I don't know, I wrote it into that. You see who it was?
I was just thinking that there's something like a lot of many colours. Because it was that is really hard with the spine, which is not possible.
Just for this class, or do you have a class?
I have other classes with teachers as
Alright, everyone, shall we just restart and we are going to look at the law, and as I've just mentioned, we're going to look at criminal law and regulation together. We'll just highlight the differences between the two, significant differences. So for some nuances, we just leave it because we're not able to cover all the details here. So in terms of who are insiders, this question, sorry. We talk about like insiders. This scope of insiders is very broad, which literally includes almost everyone possibly. But here there are strict requirements regarding mens rea and the subjects in criminal law, and these two issues are actually related. So in a criminal law, we know we usually for a certain like criminal offense, there is usually a mens rea element. And here, yes, this person knows this is inside information and knows this, he has this inside information from an inside source. So there are two dimensions in terms of the mental element. And as you can see that we talk about different standards regarding liability. This is the highest one, knowingly. Okay, and also because of this, it's hard to make a legal person as a subject of this criminal offense. So it will only apply to individuals, not companies. Do I need to interpret this a little bit further? I think this is pretty much clear. And we just need to consider the appropriateness of a crime. Okay, so we just stop here. It's not a criminology class. And there is a significant difference between regulation and a criminal offense. In regulation, no mental elements are required. The only exception is that if someone recommends or induces others to treat, and then a negligence standard applies here, this person knew or should have known what he communicated to, like for example, clients or inside information. It's the only exception in regulation. And of course, regulation applies to companies widely. So here this is a significant difference. And we know that if only individuals are subjects in the criminal offense of insider dealing, individuals may just be established. The director establishes another company just under his name, then just treat through that company he owns. He may effectively circumvent the law. Then, if we look at the criminal offense, that actually relates to the definition of dealing. So we have a quick look. Dealing. If someone procures others to treat, here procures another person, or someone actually instructs its agents to treat, and these situations cover that a director has inside information, then employs others, and these others include both individuals and persons, or instructs agents to treat, and that will effectively avoid someone making use of in this individual term and to circumvent the criminal offense of insider dealing. I'm not making any sense. So it's all covered in the criminal offense. And so that actually makes things easier because it's easier for the prosecutor to prove the mental element because you will look at the individuals and then you look at his strategies through, for example, through a company. Okay, right. So I hope that we could focus more on insider dealing here. There are several elements of insider dealing defined in law. In regulation and criminal offence, they are pretty much the same. The only difference is the first one, whether it has to be a piece of information related to a particular issuer or not. In criminal law, the answer is yes. It must be related to this particular issuer. It can't be some sort of general information about industry which this company is in, or just general market policies, regulatory public policies like the Bank of England changes interest rate, or like any tightening in like environmental regulation and so on. These types of information are excluded in criminal law, but in regulation this is relaxed. So the general information is also included. It's also defined as inside information in the regulatory context. I hope this is clear. And second is specific or precise. This is one of the focal points. Let me ask: how do you understand a piece of specific information or precise information? What is specific? What is not specific? Is there any clear interpretations given by courts, tribunals included, or regulators? Just a little bit background. Because we do not have a lot of cases in criminal law, we can't see very detailed, sophisticated interpretations provided by courts. But because pretty much in terms of precise or specific, these kind of like requirements in regulation and the criminal offence, they are just the same. So, but regulators do provide interpretations. So we look at the regulators' interpretations, and the tribunal deals with the disputes between the regulator and the market players. So we also look at the tribunal's interpretations. So here we go. Specific actually means that, precise. Let's look at precise first. Precise means that this piece of information will allow us to tell what has happened to the issuer, or what's going to happen to the issuer, or in terms of the past, we know because it's observable, this is certain. But in terms of the future, if the information is about something that's going to happen in the future, at least it will allow us to have reasonable expectations regarding what's going to happen, or the certain circumstances where this company will be in. Am I making any sense here? So when we talk about precise, it means it is indicative of the circumstances or the events. But when it comes to specific, the specific and precise, they refer to different things suggested by the information. When it comes to the specific, it means that it allows us to make a conclusion about, a general conclusion about how the information will affect the price. So it must be specific enough for us to tell how the price may change after the information is made public. So specifics about specification of the information is about the effect on the price, and the preciseness of the information is about the circumstances where the company is in or will be in. Okay, so some differences about what these two features mean here. Then now the law also defines that by which acts we can regard the information being made public. Some technical definitions here as well. Right, but I don't think being made public, this list covers all the situations. Let's have a look later where in the case of iPhone. So here we go. This is I think it's something relatively difficult because we also talk about two different standards. in regulation, let's talk about this is not printed. So which standard should be applied to define the materiality of the information? Okay, so the criminal law does not give us an answer. No courts give us an answer. So we have to look at regulation, and the market abuse regulation at the EU level implemented in the UK gives a very clear interpretation. So we will talk about a significant effect on price. So according to the market abuse regulation, we just operationalize this as any reasonable investor taking into consideration the information while making decisions. So they are identical. This is the position of the EU regulators, and of course including the FCA. Then if we look at judicial practice, here were some just disputes within tribunal itself, but in the 2014, the Hannam, this case, tribunal showed that it was on the same page with the regulators, that the reasonable investor standard is just identical with the price sensitivity standard. Or we could see that when we look at whether the information will likely have a significant impact on the price, we just look at whether any reasonable investor would take into consideration. And these two standards are the same. But if we look at an earlier one made by the tribunal in 2011, it did regard the two differently. And as a matter of judicial practice, we could see that the tribunal has overturned its own decision. But from an academic perspective, let's have a look at Massey, this case. What happened in this case, and why did the tribunal consider the two standards should not be considered completely identical? Anybody has read the case, Massey? What happened in that? So briefly, this person was a broker, and a company was going to issue new shares. He got the information, and this company issued several rounds of new shares before this issuance in question, and then in the several rounds of the previous issuance of new shares, those rounds of issuance did not significantly affect the share price. No significant changes in share price were observed. That was the background. And so now comes the new issuance, and then this company would like to issue some new shares to this person, Massey, as a broker, and before the new shares was delivered to him, he already entered into a contract with a third party to sell the shares which would be delivered to him later to the third party at a higher price, and he could subscribe to the newly issued shares at a discounted price, so he could make a profit. This was not announced because he entered into the contract before the shares were issued to him, and then the new issuance was not made public. In January, it was not made public, so that was the background. Then the SA at that time considered he treated on inside information. The inside information was about there was a new issuance, and he could purchase some shares in the new issuance at a discounted price. The third party did not have any idea. And then FCA, the Massey argued that actually, because if you look at the previous rounds of issuance, the issuance did not increase, did not result in a significant increase or decrease in share price. And these rounds of issuance, they served almost the same purpose anyway. And then we would not have any expectation it would have a significant effect on price. That's not inside information. Okay, that's the argument of Massey. And FCA was on the opposite by treating the two standards differently. So they would say that even if there may be some sort of information which investors would not think they would have a significant effect on price, but they would still take into consideration. How do you think about this argument, do you think in your imagination, is this possible that some sort of information will not affect the market price? Investors are sure that they will not affect the share price, but they will still consider. Okay, Ruben.
But because essentially the way I understood it was that the tribunal was saying that had the third party known that Massey was buying at a discount, they wouldn't have paid the price that they did.
Yes, that was this particular background in this case. Yes, because if the third party known, right, that was what the Massey was supposed to sell were the shares which would be issued, have not delivered yet, and he would put. So it was in the new issuance, and then the Massey Massey could purchase at a discounted price. So yeah, that means they could perhaps wait. The third party could perhaps, if they had known, they perhaps could wait until the announcement of the insurance, and then wait if the price might go down. So that was the point of the FSA. They would definitely consider the general background. They would not be happy to treat after if they had known that the seller could purchase at a discounted price.
But if the argument is that they wouldn't have traded at the price they did had they known it was discounted, then surely the fact that it's discounted is necessarily affecting the share price. Because if buyers aren't willing to pay at the market rate because it's bought at discount, then the market rate will drop until somebody is willing to pay. So I don't understand how this would not have an effect on the market price.
So the arguments based on different grounds, because the Massey argued that we should not base on the fact the inside information itself, or the inside information in this case, we should base on what the information the third party had before entering into the contract, because looking at the previous new issuances, there would not be any significant effects on share price. Does this make any sense? So they based their arguments on different grounds. Massey said, well, the third party should not consider the background in question. So about the information about this new issuance, they should consider previous issuance to make kind of like an evaluation or judgment prediction what the new issuance would, the potential effect of the new issuance, whereas then the FSA base their arguments on if everything, just the specific details, particular details, had been disclosed to the third party evidence.
In this transaction, the shares which Massey sold to as a broker, they weren't sold onto the open market, right? They were sold directly to like.
That's I think that's a very important issue. Yeah, that's through the private placement.
Yeah. This private placement
may not have an impact, or may not have an impact on price.
And we also don't. I mean, I haven't read the case, but maybe there's some kind of agreement as to how long the buyer has to hold the shares because it's a private placement.
You mean like a lock-up period?
Yeah, exactly.
Oh, I don't think so. At least in this case, no any lock-up period. The fact was, the background was that they worked together. Massey worked together with the issue company or the lot, and the issue company was aware he was a broker. He won't hold the shares himself for quite long. They intended that through him, he could sell the shares at secondary market. Right, let's here just pretty much this was just a different approach adopted by the tribunal in a very different, very particular background. That what I want to conclude here is that possibly there may be some sort of information which investors may not expect to have a it will have a significant effect on price, but they may still take into consideration given the whole picture. And if this approach is adopted, then we will have a broader definition of inside information. And then this will help us, or help regulators to perhaps identify insider dealing more easily, because if we look at likely have significant effect on price, this means that, but why do we use likely instead of removing it? Because we know share prices are affected by different factors. We can't just, regulators can't just rely on the ex post observation of the changes in share prices, because some sort of information may be supposed to have a significant effect on price, but the result is that after making public, it does not have a significant effect, or there are other factors which offset its effect. So we can't rely on observable changes afterwards. We must give the definition to significant effect on price. And when we use reasonable investor standard, we also need to ensure that it's broad enough to include all possible situations where investors will take into consideration. And then even if in a particular case investors did not expect a significant change in price, but they may likely to take into consideration this kind of like a very small gap in between should be included, and then we can broaden the definition of inside information. I'm making any sense here. Okay, we then have to move on to, but likely there is also an interpretation. The tribunal just rejects to say there needs to be a very high level certainty or high level probability, so that's it. And we probably talk about dealing. The only difference I want to highlight between criminal offences and regulation is that here is a broader definition of dealing in regulation, which also includes, for example, placing an order, even if the order final was not executed, or also including, for example, attempting to treat based on inside information. Despite that, it's not that easy to, even if in the regulatory context, it's not that easy to prove or to detect. Okay, so I hope that we'll probably need to go back to the Einhorn case a little bit, and let's have a look at that case here. We'll focus on whether the information in this case is inside information, basing on the four elements of discussed as cited in the criminal law here. Have you read this case a little bit? So can someone try to summarize the facts a bit? Anyone? Ruben, please.
So this company Punch wanted to bring in Einhorn and somebody else. I think it was a third party that was representing another company that was potentially investing, from what I remember. And they wanted to bring them in to have a meeting to discuss on a confidential basis whether they would like to buy shares in a new issuance. And Einhorn said no. And then later, in a social context, they had a discussion about it, but it was not a meeting. Einhorn never agreed to it being confidential. It was just in a social context. I thought it was at a party, and they got talking, and then this person from Punch mentioned that there was this potential investment coming. And based on that, Einhorn didn't want to buy any shares in the new offering, and he sold his current shares. And then when the new offering came, the price dropped, and the regulators, or I thought the company with the regulators went after Einhorn and said, you sold these shares based on inside information, and Einhorn said, well, I never agreed to it being confidential. This was told to me at a party. I had no way of knowing that this was actually inside information.
Fantastic. So here's the dispute actually, well, not actually whether there was a duty, not American scholars thought about. I think the focal point, the question is whether the information was inside information apparent by Einhorn and the FSA, their opinions were just opted. Let's have a look. I think the information here, it was just particularly related to Punch, so there's no any problem here. and what we need to focus on is whether it's specific or precise in this case. If you have read the case, any opinions, you don't need to stick to the FSA's position or Hong's position. How do you think about in this particular case? Because the call was supposed to be what they call annual cost, which was not confidential, and then there were only we could say that the information about the entire new versions was just communicated to Einhorn on a piecemeal basis. So there were just some details, not the whole picture, and nothing was made conclusive. Perhaps was this supposed to be precise and specific? Any ideas? What do you think? First of all, was the information precise, specific in this particular case? Ruben, do you think?
Well, I think it is specific enough because they're talking about a specific event, a specific equity offering.
Mm-hmm.
The fact that it's not yet 100% definite that it's happening, I don't think is massively relevant because the specificity thing is about likely or reasonably, a reasonable person would consider it likely to happen. I think if they're talking to investors about it, that standard may well be met. And on the confidentiality basis, I don't think the fact that it's confidential or non-confidential is relevant to insider trading. I think it's relevant if they want to go after him for breach of confidentiality. If he disclosed it to another third party, that's a different thing. But insider trading, in my head, doesn't have much to do with the contractual basis of signing an NDA. It's about whether the information is disclosed to the public, which Einhorn probably knew it wasn't, because he was being told specifically in a private meeting, alright, it wasn't in a business context, but I don't think that's relevant to whether it's public or not.
Okay, yeah, brilliant. Let me try to argue with you. Let me try to pretend to be Mr. Einhorn. All those details communicated to me were just, as I saw, just on a piecemeal basis. None of them would be able to allow me to make a conclusion. And then because I have expertise, professional knowledge, and I know background generally, I pieced up those different pieces of information. That's my own knowledge. That is not inside information. My investments, or not investments, the sale of the shares was based on my knowledge, not inside information. So they didn't communicate explicitly or as a whole picture to me. Just told me some sort of details and not conclusive. And then I made reference based on what communicated to me.
I think that your professional experience and knowledge is a lens through which you interpreted the information. But the fact of the matter is, there was still information which you had to interpret because you were given information. Whether your experience meant that you perceived it in a particular manner, I don't think is particularly relevant to whether it's insider information or not.
Good. And Louis, please.
Could you also make the argument that, a reasonable trader, based on the information that you received, even though yes, you may be an expert, any other reasonable trader would also draw the same inferences from the information you received, and therefore that would be sufficient for it to be
specific and precise.
Specific and precise, yeah.
Okay, very good point. Ben, would you want to?
There's one thing that I get a bit confused with this whole insider trading bit is, why is it illegal to protect yourself? He's not going out his way to benefit from taking money or opportunity from somewhere else. He's carrying out his duty to him and his company on information he stumbled across. This person told it to him. So it's say if I worked at a company and I stumbled across the fact that our company is going to sell this and I know it's going to tank and I own a large portion of it, why is that wrong for me to then sell it to avoid the loss? I don't get why that's illegal.
Yeah, the point is, if this is let's following MSA's position. If this is insider dealing, are not allowed to avoid the laws, even if this is considered that you are exercising as a fiduciary for the clients, for the clients. But even if this is no matter to avoid the laws or to make a profit, you must do so through legally defined legitimate actions, not illegitimate actions. And the issue is that whether this is insider dealing, if is this defined as insider dealing in law, then it is illegitimate. And so that's why we need to clarify what is insider dealing in law. And here, when it comes to regulation, it just becomes very easy. Someone has insider information, is in possession of insider information, then he treats the relevant securities. If the two acts are completed, that's insider information, unless there could be some rebuttals based on reasonable grounds provided by the insider that's in regulation.
Yeah, what I'm thinking is, so he's found out this is going to happen, and he obviously avoided the loss of 5.8 million or something like that. So legally, he should have just sat there and done nothing and lost 5.8 million. So, like, what's the reasonable thing? But why the reasonable person wouldn't do that? Like, if that was me, I would probably do what he did, not knowing if it was insider trading or not, because that would be the reasonable thing to do.
I got the
to protect myself from losing money. I know he ended up getting fined like 3.6 anyways, but he still was better off. So he actually came better off from doing it than he didn't. So it doesn't really, I don't see the rationale behind the rulings and.
That's fantastic. I think this is the business logic, and we didn't even pay attention to how much the fine was. Brilliant. Louis, yes.
I think the argument is that you avoid the loss of that £5.8 million, but then the other investors, didn't have the opportunity to also avoid that loss, and in fact will feel the loss more because you've pulled out. So I think the argument is that, okay, yeah, you could have avoided the loss, but it's that you shouldn't have avoided the loss. That when you made the trade, if we allow you to avoid that loss, it means that other investors feel the injury more, and then that would then impact confidence in the market and reduce overall investment in the economy. I think that's the argument of how you say that's why you should just have to bear the loss.
Yeah, what I consider is as economic man, where we are reasonable investors, we always want to avoid other losses or make profits for ourselves, no matter this is at the expenses of another's interest or not. And that's the role of law, to ensure that economic men or reasonable people will not just pursue private interests at the expenses of others. If I could kind of like summarize at a relatively general level, right here, so we can see like the kind of like a division between the legal logic and the business logic. And so any questions so far about one?
If you were to take another type of financial product in this situation, like a hedge position.
The position remains.
So, for instance, you have news that, news that may impact the price of a company's stock to go down, and so, or to go down. So you hedge your position by buying like an index swap.
Okay, that's not insider dealing.
That's not insider dealing.
That's not insider dealing.
Okay, cool.
If when you treat a relevant, that's not insider dealing in law. Then when you treat a different security, let's see, or we will talk about in the context of manipulation, and that's still a dispute whether it's not about inside information any longer, it's about if you manipulate the security of the price, and then you actually do not treat that security after the price is affected, you're going to treat another relevant securities derivatives, the value of which is based on that manipulated security. That may be an issue, but when it comes to insider dealing, that's not insider dealing at all.
Cool.
Okay, so because despite that you utilize insider dealing, but if you do not treat the relevant securities, we're just treating some another kinds of financial instruments to hedge. I don't think that's okay. Questions?
Does insider trading only apply to trading of actual securities,
Actually,
not derivatives? Like futures or forwards or options?
It depends on whether the information is about futures or forwards or no.
So it's only the product which the
It's
information
sort of-
directly concerns.
Yes.
Well, I was going to ask if you're doing some kind of option on an index and the company is part of the index, like to what extent is the information relating to that security? If it is part of an index that you either buy or short or something like that, or you do some kind of futures on it, it's part of the index, it will affect the price of that index. Is there a materiality?
The thing is,
level
I think as a matter of practice, I don't really think. I think there is a very high level of uncertainty to what extent the information about a particular investor or issuer will affect the whole index. That's what I can
I
say.
have an example. It's not been removed, but say like a couple of years ago, Tesla was probably 25-30% of most ESG index fund listed funds. Say you had information that may lead to Tesla's price going down, it would have a significant impact on the index fund. So if you were to buy a derivative in that index, there's a pretty strong link there just because of the size of the stock as a portion of the market cap of the whole index.
That's really a very good question. But I think the only thing that perhaps we'll look into the details of a specific case, and then if we need to apply, let's say, the materiality, and I think we'll probably need to consider to what extent that price or that information will affect indirectly on the relevant instruments. I don't really think we can, for certain or for sure, we could see that we can include the trading of not directly affected level securities into insider dealing. That's what I think. Probably because we don't really have interpretations in regulation, we don't really have any court cases. We don't have any rulings for the time being. So that's my understanding is that we usually do not extend insider dealing to indirectly affect it, or perhaps there is a high level uncertainty whether it will affect. But if it does affect, then yes, perhaps that may be considered as insider dealing in particular.
Wouldn't that defeat the whole purpose of insider dealing legislation then? Because the credit market and the secondary market is much larger and much more available than the primary market. For a lot of shares of stocks and everything, you could find derivatives on it pretty easily. So Tesla, like the example with Tesla, you could buy options and sell options and short and do all kinds of things, and you don't have to report it necessarily. And
in private markets? In private markets?
In publicly traded secondary markets.
Okay, so in public markets, you mean?
Yeah, like you could trade options on it, or just straight futures, and then it would impact the share price undoubtedly, and because it's much more available compared to actual shares of stock as well, like the actual liquidity of the
Do you mean
derivatives.
that you may treat stock options? They will affect, of course, the price of the stock options, and then that will also affect the price of the stocks.
Yeah.
And that's perhaps market manipulation, because they manipulate the price of one security, they will affect the price of a relevant security. And it does not necessarily is that information. But what I want to get back to the point is if it's stock options, I think it's a direct link. That for the index cases, I think it looks to me ambiguous. So I don't think there's a but high probability or likely have a significant effect on the price. I think Luis or Victor, do you have questions about? Or Luis, I think you may want to talk about that.
Sorry, just quickly. So if you were to like say, I was just thinking about the index trading. So if you were to get, like you said, if you got inside information that would influence the mind of a reasonable investor who would deal in that index, or something would you probably argue that, well, I know this information is going to affect the index, so I'm going to, sell all my shares in the index to affect the stock, and then that still allows you to avoid the loss that you'd suffer, and then still affect the rest of the market probably, even though it's maybe watered down if it's only one company. You could probably argue the overall justification is still the same, I think.
Selling, well, I mean, instead of, the question is if when they sell the whole index, they sell the shares of the company.
Yes.
That's the point that's inside the but for others,
Right.
okay, not really. Okay, so probably the end. We covers that, so let me just briefly cover on. So it's presumption of use, presumption of the position between the possession of inside information and the trading. So it's presumed, and the regulator does not need to prove unless the insider argues that I would have done so regardless of the inside information. Okay, and there are some defenses. Okay, so that's everything for today. Let's see whether we could have another look at this back later. Okay, so in the summary. Okay, so that's everything, and thank you very much, guys.
Thank
Thank you.
Hey.
That's a good point, because like, say there's antitrust legislation, which there is against like Google and Facebook, and you if you know what's